Happy Monday morning, everybody. Just firing up my computer here. Wanted to make a couple quick videos before I go to work. Let's talk about hearsay. I've been a trial attorney for 26 years. Within the context of trials, I have dealt with hearsay quite frequently over the last couple of decades. What is hearsay? Hearsay is a statement that was made outside of court that asserts facts and is now offered in court to prove the truth of the facts asserted. What does that mean? We frequently see hearsay statements, essentially victim statements, in cases that involve sexual harassment, sexual abuse, sexual assault, things like that. Because frequently people who are victims of those types of activities will make statements to other people at the time. At the time, those are called contemporaneous statements. Statements at the time that an incident occurs, that when the matter a couple, 3 years down the road comes up for trial, one side will seek to introduce those statements that were made contemporaneously to a sexual assault and will attempt to introduce those statements into evidence as factual, as proving the fact that something occurred. And however, every state has multiple exceptions to the hearsay rule. California has more than 25. We'll talk about those in a second. But most recently, what's a real world example where we saw hearsay being offered for the truth during a trial, an out-of-court statement being offered for the truth during a trial, and certain exceptions were applied to allow those statements to come into evidence? The E. Jean Carroll case. In the early 90s, even though her trial on these issues didn't take place until 2022, I think, she alleged during that trial that she had been sexually assaulted by Donald Trump in a dressing room of a department store in Manhattan. She further alleged that at the time that assault took place in the early 90s, that immediately after that assault took place, she had called two of her friends individually in two separate phone calls and described to them at the time what had just happened to her, what Donald Trump had just done to her. And almost 30 years later, when the case came up for trial, she and her legal team wanted to call those two friends as witnesses to say she told them about this at the time. So there are layers to this. What would not be hearsay in that context? Well, it would not be hearsay that those two phone calls took place. They could ask E. Jean Carroll, did you call so-and-so on this date at that time? Yes, I did. That is factual about what happened without getting into the substance of what was said. And currently, we see this a lot with emails, DMs, other types of electronic communication, text messages. Did you text or email so-and-so on this date at that time? Yes, I did. And you usually have documentary evidence to corroborate that. The fact that that communication took place is not hearsay. What would be hearsay would be the substance of those communications. Like, did you speak to so-and-so on this date at this time? Yes, I did. What did they tell you? That's hearsay. But what are some exceptions to the hearsay rule? Admissions. If a perpetrator speaks to someone before a case comes to trial and they admit to another person that they did something, that's admissible, at least in California, under an admissions exception, or an adoptive admission. If the perpetrator says to their friend, I did X, Y, and Z, and then their friend thereafter behaves in a manner as though they believe what that person told them, they have adopted that admission. State of mind is another one. You can talk about what a person's state of mind was at the time. Declarations against interest. A person who says something that is against their own interest, that can be an exception to the hearsay rule. A prior consistent statement. If someone said something back then, like in the E. Jean Carroll case, a prior consistent statement. What E. Jean Carroll alleged to have told her two friends in the early 90s is consistent with what E. Jean Carroll was saying during her trial when she was alleging that Donald Trump had sexually abused her. So there are all kinds of exceptions to the hearsay rule that can make otherwise inadmissible statements because they were made outside of court, not under oath, just to one other person in one conversation, that can make those kinds of statements admissible in court. And let me see if there are other ones that apply here. Contemporaneous statement. Evidence of a statement is not made inadmissible by the hearsay rule if the statement is offered to explain, qualify, or make understandable the conduct of the person who's testifying about that statement, or was made while the declarant was engaged in that type of conduct. State of mind we mentioned, and there are all kinds of exceptions to the hearsay rule if the statement itself is in writing, like again, in an email or a text message. So again, there are all kinds of exceptions to the hearsay rule, but most importantly, when there is a jury trial, like there was in the E. Jean Carroll case, the jury decides what the facts are. They watch and listen to witnesses testify. They're weighing the weight of each witness's testimony and each witness's credibility. That credibility can be enhanced if there are multiple witnesses sharing very similar stories. And if those multiple people sharing similar stories had made multiple out-of-court statements to others about the conduct of one individual, and through these exceptions, they're allowed to testify about things, or the people that they told at the time, here's what happened to me, and somebody tries to call those witnesses who heard these stories, then you get a cumulative effect. And that cumulative effect, if the stories that all of these witnesses are telling are similar enough in nature, then that bolsters the credibility of the witnesses who are offering this testimony, obviously to the detriment of the alleged perpetrator. So it's like, you know, it just gets frustrating to me as someone who's been a trial attorney for almost 30 years that, you know, people understand the idea of hearsay. You can't testify in court about what somebody else told you outside of court. And yeah, that's the starting point, but that's just the starting point, because there are a couple of dozen at least exceptions to the hearsay rule in every single state in this country. And it's not a question of getting around it. It's a question of making sure that the jury gets the information that they need in order to reach a truthful verdict. You know, the word verdict it's derived from the Latin word veritas, which means truth. And, you know, so I just wanted to kind of clear up that misconception. I saw a couple of TikToks this weekend, people spouting out the word hearsay while having no real understanding of what it means and what the exceptions are and what people are and are not permitted to testify about in court. So it's important. It's something I run into all the time in the work that I do. And, you know, it's like people who watch Law and Order and say that's hearsay, and then they're like, oh, okay. And they think that it's just this kind of like hard, fast brick wall that prevents people from testifying about certain things, and that's just not the case. Let alone, let alone in the court of public opinion. But it's like if you have an admission and you have multiple victims in a situation, and they have told their stories to other people, chances are really good that even if the victims don't want to come into court and testify, those other people will be permitted to come in and testify about what those victims told them outside of a courtroom. So hearsay is an important thing. The exceptions to the hearsay rule are equally important. So hope that helps.